Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk about the 3 ways that you can contest a will or a trust. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to estatemeeting.com. Estate with an E, estatemeeting.com. Okay, this came up today in a client call. I was reviewing a trust with a client, and we talked about the no contest provision. And people always want to make sure the no contest provision is included, which is important. But then we also talk about what are the ways that you can actually contest a will or a trust. People are often concerned about someone being grumpy or disgruntled or coming out of the woodwork and wanting to try to contest those estate planning documents so that they can get a share of the estate. And in reality, contesting estate planning documents is pretty tough. It's a high standard, and there are 3 main ways that people can contest estate plans. The first is the simplest, and that is just that the documents themselves were not executed properly. I can't tell you how many wills I've seen come in for probates that were missing notaries or were missing witness signatures or things like that, where they just were not executed properly. If that's the case, then the document just doesn't work. And if you catch that too late, if the person's already died, for example, you can't fix that problem. And that's why it's important to have someone help you most of the time fill these out, just so you can make sure that you're overcoming these low hurdles to success. Okay, so number 1, documents not executed properly. Number 2, the second way that you can contest an estate plan, contest a will, contest a trust, is by claiming that the person did not have the capacity to sign those documents when they did. Now, what do we mean by capacity? Basically, an understanding of what the documents are, an understanding of what they are doing with these documents, and an understanding of the direction that's inside of those documents. Typically, we're talking about who are the named trustees, how are we doing the distributions, things like that. And when it comes to capacity, that can rear its head in many forms, but often we're talking about a lack of capacity because of some sort of mental deterioration, Alzheimer's, dementia, right? These kinds of things where people simply lose the understanding of what they're doing, and they are opening themselves up potentially to be taken advantage of by people. That's why we have witnesses that sign these documents. That's why we have people in the room that are sort of there to determine these things, at least at a very, very high level, certainly not at a professional level, but can at least opine as to whether or not the person had the capacity to sign the documents at the time that they did. For me, with my clients, when we do these signings, I always ask them, do you understand what you're doing by signing these documents? They say yes, then we keep going. If they say no, then we figure it out. So that's number 2. The third way that you can contest a will or a trust or any other estate planning document is that it was signed under duress. What do we mean by duress? We mean sort of any kind of pressure that's making someone do something that they don't want to do. The easiest way that you could create duress is if someone was pointing a gun at someone and saying, sign those documents. That is clearly duress. But there can be other economic pressures that are sometimes put on people. I know I've heard stories, I haven't had clients actually have this happen to them, where there's an elderly client, let's say, and they are being taken care of by someone, and that person is saying they are going to take away that care, or they're going to kick them out of the house, or they're going to do this or that if they don't sign these documents. That is duress. All right, so these are the ways that you could contest a will or a trust or other estate planning documents. A, they're not signed correctly. B, there was no capacity to sign at the time. And C, the signing was done under duress. Like I said, these are relatively high barriers to reach. You need proof. You can't just make allegations. And things do happen, though. It does happen. So if you are worried about those things, get help and make sure that you button all those holes up. Okay? All right, that's it. As always, if you like this video, please hit the like button. If you have a question or comment, please leave it. I will answer. And if you know someone needs to hear this, please share it with them. Okay? As always, if you need help, if you have questions, comments, if you want to get your estate plan done. You can go to estatemeeting.com, set up a time to talk with me over the phone for free, estatemeeting.com. All right, that's it, everybody. I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.